The gavel never made it down. Marguerite Doss Kellerman had it raised, halfway through calling the July meeting of the Red Hollow Ranch Estates Homeowners Association to order, when 61 people in a rented function room at the Larkspur Hollow Grange Hall started shouting over each other at once. Somebody's folding chair went over backward. A woman near the coffee urn was already crying, the kind of crying that comes from doing the math on a mortgage and a road at the same time. Todd Farrar, the HOA's vice president, stood at the front with a sheet of paper trembling in his hand, like it might catch fire, and when he finally got enough quiet to read from it, his voice cracked on the second sentence. "The association," he read, "has received formal notice that homeowner Walter Voss has filed suit to terminate the easement granting Red Hollow Ranch Estates its access to State Highway 46. Somebody in the back said, out loud, to no one, 'He's taking the road.' He wasn't taking the road, not yet. But by the time this was over, a jury in the 274th Judicial District Court of Brannigan County, Texas, would decide that the road had never really belonged to the 60 families of Red Hollow Ranch Estates in the first place, that they had been driving across another man's cattle ranch for 21 years on a license that expired before half of them ever signed a mortgage, and that the only reason nobody noticed was that nobody had bothered to read the deed. Walter Voss had read the deed. Walter Voss had, in fact, drafted large portions of it himself, back when he still had both knees and a job title that ended in PE. He was 68 years old, 412 acres deep into what was left of his father's cattle operation, and he was about to become the reason an entire subdivision discovered that "the only way out" is a phrase that means something very different to a lawyer than it does to a homeowner writing a check every month to live at the end of it. Drop your city and tell me, do you live in an HOA? I want to know how many of you are watching this from behind enemy lines right now. Before the lawsuit, before the meeting, before the crying woman by the coffee urn, there was a ranch. And before there was a subdivision named after it, there was a man named Ellis Voss, who ran 300 head of Santa Gertrudis cattle across nearly 600 acres of caliche and live oak, about 40 minutes northwest of San Antonio, in a stretch of Brannigan County that the highway department had, for decades, considered too far off the main road to bother widening. Ellis Voss died in 2001 with a ranch, a widow, and a son named Walter, who had left for Austin at 19 to study civil engineering and had spent the next 22 years designing drainage systems and access roads for the Texas Department of Transportation. Walter came home to bury his father and stayed to bury his mother 2 years later, and somewhere in between, he inherited 600 acres he had no earthly plan for, and a stack of unpaid property taxes that made the decision for him. In 2003, Walter Voss sold 180 acres of the ranch's northeastern corner to a development company called Meridian Land Partners, LLC, run by a developer named Callum Reyes, who had a nose for cheap land within reasonable commuting distance of San Antonio and absolutely no interest in ranching. Reyes wanted to build 60 single-family homes on half-acre lots, call it something that sounded like a place people would want to raise children, and sell every one of them within 3 years. He called it Red Hollow Ranch Estates, because ranch sells in Texas, even when the closest thing to livestock left on the property after grading is a taxidermied longhorn skull screwed above the entrance sign. There was, however, a problem, and Walter Voss, who had drafted the language himself, because in 2003 he still trusted Callum Reyes to act like a reasonable businessman, had flagged it clearly in the closing documents. The 180 acres Reyes was buying had no direct frontage on State Highway 46. The only practical route from the new subdivision to the highway ran directly across the 412 acres Walter Voss was keeping, down a ranch road Ellis Voss had graded himself in 1974, past 2 stock tanks and a working set of cattle pens, through a single-lane cattle guard that had been rattling under pickup trucks since Nixon was in office. So the deed included an easement, recorded as instrument number 2003-014477 in the Brannigan County Real Property Records. It granted Meridian Land Partners LLC, and, by extension, whatever homeowners association eventually took over the development, a non-exclusive easement for ingress and egress along the route designated as Ranch Gate Road, and it capped that easement at 10 years from the date of recording, or upon completion of the subdivision's Phase 2 build-out, whichever came first, unless both parties executed a written renewal. Walter Voss had built that clause in on purpose. He had assumed, reasonably he thought, for an engineer who spent his career reading right-of-way documents, that a permanent access road serving 60 homes would eventually get its own frontage improvement, or that the developer would negotiate a permanent recorded easement with fair compensation once the development was established, the way it's supposed to work. He had not assumed that Callum Reyes would sell out to the newly formed Homeowners Association in 2006, take his profit, and vanish to a golf community outside Scottsdale, leaving behind 60 families who had never once been told that the road they drove on every single day had an expiration date printed into the county records. Nobody read the deed. In fairness to the 60 families of Red Hollow Ranch Estates, almost nobody reads the deed. They read the listing, they read the school district rating, they read the HOA fee, $140 a month in 2006, up to $210 by the time this story catches up to the Grange Hall meeting, and they signed. The community's covenants, conditions, and restrictions, recorded the same year as the HOA's formation, referenced the association's access easement in Article 7, Section 7.3, under road maintenance obligations, without ever specifying that the easement in question had an expiration clock running since 2003. That clock ran out on August the 14th, 2013. Nobody noticed. Ranch Gate Road kept getting driven on. School buses kept turning down it every weekday morning. The HOA kept collecting dues, some of which theoretically went toward a road maintenance reserve fund that, as it would later come out in discovery, had accumulated $11,000 over 18 years, barely enough to patch potholes, let alone renegotiate an easement nobody in the association's leadership even remembered needed renegotiating. Walter Voss noticed. He noticed in 2013, in fact, right around the time the 10-year clock expired, because that was also the year he retired from TXDOT and moved back into the ranch house full-time to run what remained of his father's cattle operation, Voss Cattle Company, 140 head of Santa Gertrudis, on 412 acres, a herd small enough to be a labor of love and just large enough to keep the land under an agricultural exemption. He noticed the expiration date because he had written it, but Walter Voss, at that point, was not a man looking for a fight. He liked his neighbors well enough. He waved at the school bus. He let the HOA's board president at the time, a genial retired schoolteacher named Barbara Suttle, walk her dog across the cattle guard without complaint, and when Barbara asked him, somewhat sheepishly, in 2014, whether the association needed to do anything official about the road, he told her he'd draw up a simple renewal agreement, they'd both sign it, and life would go on. He drew it up. He sent it to the HOA board in March of 2014, a one-page renewal, extending the easement another 20 years, at a modest annual maintenance fee of $6,000 a year to be split among the 60 homeowners, roughly $100 per household per year, to go toward regrading and cattle guard maintenance on a road that, after all, 60 families and their combined mail carriers, propane trucks, and school buses were putting more wear on than one man's cattle ever had. The board tabled it. Then they tabled it again, in 2015. By 2016, Barbara Suttle had moved to be closer to her grandchildren, and the presidency of Red Hollow Ranch Estates Homeowners Association passed to a woman named Marguerite Doss Kellerman, a real estate agent with strong opinions about curb appeal and an even stronger conviction that anything requiring the association to spend money was, by default, a bad idea unless it involved decorative entrance monuments. Marguerite found Walter Voss's proposed easement renewal in a filing cabinet in 2017, decided the annual fee was predatory, and never brought it to a vote. Nobody told Walter Voss it had been rejected. Nobody told him anything at all. The renewal simply sat, unsigned, in a drawer for 7 more years, while Ranch Gate Road kept getting driven across 412 acres that, on paper, the association had no legal right to touch. Now that you know Walter Voss, has your HOA ever pulled something that made your blood boil? Tell me the worst thing your HOA has done, because I promise you, this board is about to get so much worse. For a while, worse looked like small things. In 2018, the association installed a set of speed bumps on Ranch Gate Road without asking Walter Voss's permission because, as Marguerite Doss Kellerman put it at the time, it's basically our road at this point. Walter said nothing. He was a patient man, and speed bumps, while technically an unauthorized improvement on private property, weren't worth a fight. In 2019, a newly elected board treasurer, a soft-spoken accountant named Priya Nandakumar, discovered the 7-year-old easement renewal proposal buried in board records and brought it up at a meeting, suggesting the association at least acknowledge, formally, that they were using someone else's land. Marguerite dismissed the idea as opening a can of worms, and the motion died without a second. In 2021, Todd Farrar, at the time still just a resident, not yet vice president, filed a formal complaint with the association's architectural committee about the smell coming off Voss Cattle Company's working pens, which sat roughly 400 yards from the subdivision's rear property line. The complaint cited no HOA authority whatsoever, since Voss's ranch wasn't part of the association and never had been. But Farrar copied the county on it anyway, invoking Brannigan County Code Section 14-1118, the county's agricultural nuisance ordinance, alleging that cattle odor and flies constituted a public health nuisance affecting property values in Red Hollow Ranch estates. The county responded, correctly, that Voss Cattle Company predated the subdivision by roughly 80 years, operated under a valid agricultural exemption, and was protected under the Texas Right to Farm Act, which shields established agricultural operations from nuisance claims brought by neighbors who moved in after the fact. Walter Voss received a copy of the county's dismissal letter and a copy of Todd Farrar's original complaint, and read both of them standing at his own kitchen counter with the particular stillness of a man recalculating exactly how much goodwill he had left to extend to people who were, quite literally, using his driveway. He extended it anyway, for 3 more years. That was the kind of man Walter Voss had built himself into, over 4 decades of writing right-of-way agreements for the state of Texas. He believed, stubbornly, that most problems could be solved with a clearly worded document and a reasonable conversation, and that going nuclear on your neighbors, even neighbors who filed nuisance complaints against your cattle, was the kind of thing you did only after every other option had been formally exhausted, documented, and dated. Then, in January of 2024, the association's board, now led by Marguerite Doss Kellerman as president, with Todd Farrar as vice president, and Priya Nandakumar still hanging on as treasurer, outvoted every time she raised the easement issue, approved a special assessment. Ranch Gate Road, the board announced at its January meeting, was overdue for repaving and widening from 1 lane to 1.5. To accommodate the increased traffic from Phase 3 construction, a set of 8 additional lots the association had decided, without consulting Walter Voss at all, to carve out of a strip of land along the road's northern edge, land that belonged, entirely and unambiguously, to Voss Cattle Company. The special assessment came to $2,400 per household, due within 90 days, for a total project cost of $144,000, the majority of which, per the paving contractor's bid attached to the board's meeting minutes, was allocated to widening the road onto property the association did not own, and had never owned, and had no easement rights to touch beyond the narrow ingress and egress strip Walter Voss's father had graded 50 years earlier. Walter Voss found out about the special assessment the way he found out about most association business by then. From a neighbor, a retired Air Force logistics officer named Dale Crenshaw, who lived at the end of the cul-de-sac closest to the ranch gate, and who still, out of old habit, waved every time he drove past. Dale mentioned the repaving project in passing, over the fence line, the way you'd mention the weather. Walter asked him, evenly, whether the association had contacted him about surveying the additional right-of-way they'd need. Dale said no. Walter said thank you. And that same afternoon, for the first time in 11 years, Walter Voss drove into town, sat down across from an attorney named Renata Ibarra Cole at her office on Larkspur Hollows Town Square, laid instrument number 2003-014477 on her desk, and asked her a very specific question. What happens to an easement exactly? When it expires, the servient landowner never renews it, and the dominant estate keeps using it anyway, for 11 years without so much as a signed acknowledgement. Renata Ibarra Cole read the deed twice, checked the county's real property records to confirm the instrument number and the recording date, pulled Texas case law on prescriptive easements and easement termination for the better part of an hour, and then told Walter Voss something that would eventually cost 60 families their only paved way to the highway. They don't have one, she said. Not legally. What they have is an easement that expired in 2013, that they never renewed, that you never formally revoked, and that they've been using ever since on what's called, at best, an implied license, which you can terminate, legally, anytime you want, with notice. $2,400 per household, against Walter Voss's own cattle land, without his consent. Is this legal where you live? What would you have done in his boots? Walter Voss did not, in fact, terminate the license the day he heard that. Renata advised against it for a straightforward reason. 60 families lived at the end of that road, and cutting off access without warning, even access the law didn't obligate him to provide, would look, to any jury, exactly like what it was: an old man using a legal technicality to strand his neighbors. Renata Ibarra Cole had spent enough years practicing real property law in Brannigan County to know that being technically right and being defensible in front of 12 jurors from the same county were not always the same thing. She told Walter to do 3 things, in order, all of them documented, all of them dated, all of them designed to give Red Hollow Ranch Estates Homeowners Association every reasonable chance to fix this before it became a lawsuit. First, send a formal letter, certified mail, notifying the association's board that the recorded easement had expired in 2013, that the association's continued use of Ranchgate Road since that date constituted a revocable license rather than a legal right, and that Walter Voss was requesting, again, a negotiated, written, permanent easement agreement, with fair compensation for maintenance and for the additional wear and tear 60 households placed on a private ranch road. Second, formally and explicitly object, in writing, to the association's planned widening project, on the grounds that it required taking additional acreage from Voss Cattle Company that had never been surveyed, appraised, or offered for purchase, and that any construction crew that crossed onto that acreage without a signed agreement would be trespassing. Third, wait. Give the board 90 days to respond. Like reasonable people managing 140 homeowners, one and only route to civilization. Walter Voss mailed that letter on February the 9th, 2024, from the Larkspur Hollow Post Office, and got the certified mail receipt back 9 days later, showing it had been signed for by Marguerite Doss Kellerman personally. The board's response, when it finally came in March, was not a negotiation. It was a letter from the association's own attorney, a general practice lawyer out of San Antonio named Grant Pelletier, who, as would come out later, had never actually reviewed the original 2003 easement instrument before drafting his response, asserting that Red Hollow Ranch Estates Homeowners Association held a vested, permanent right-of-way across Voss Cattle Company by virtue of over 20 years of continuous, open, and notorious use, and that any attempt by Walter Voss to interfere with that access would constitute unlawful interference with an easement and expose him to significant liability. It was, Renata Ibarra-Cole told Walter when she read it, an argument for a prescriptive easement, the legal doctrine that lets someone acquire a right-of-way through years of open, continuous use without the landowner's permission, the same way adverse possession lets you eventually claim ownership of land you've occupied long enough. It was also, she pointed out, an argument that collapsed the moment anyone checked the actual facts, because a prescriptive easement requires use that is hostile to the landowner's rights, meaning without the owner's permission. And Red Hollow Ranch Estates' use of Ranchgate Road had never been hostile. It had started with an explicit, written, permissive easement. Permissive use, no matter how many decades it continues, cannot ripen into a prescriptive right, because the entire doctrine exists to protect landowners who never consented in the first place. The association's own lawyer had built his defense on the one legal theory the facts of the case flatly contradicted. The board moved forward with the widening project anyway. On April the 3rd, a survey crew hired by the paving contractor showed up unannounced at Ranchgate Road and began staking out a right-of-way line that ran, in places, nearly 40 feet onto Voss Cattle Company land, directly through a working set of cattle pens Walter's father had built in 1981. Walter Voss came out of his house that morning in a bathrobe, watched the survey crew for 11 minutes without saying a word, then called the Brannigan County Sheriff's Office and reported a trespass in progress on posted agricultural property. Deputies arrived, confirmed the crew had no recorded easement, no county permit, and no written authorization from the landowner, and asked them to leave. The foreman, a man named Del Aycock, who ran a small paving outfit out of Bourne, would later testify that Todd Farrar had personally assured him the association owned that strip, no question, and that nobody from the HOA had mentioned needing Walter Voss's sign-off at all. That was the moment, Walter would say later, when a reasonable disagreement between neighbors turned into something else. Not because a survey crew got sent home by a deputy. That, in the end, was a minor embarrassment the board could have walked back with an apology. It was because 2 days later, on April the 5th, the association filed a formal complaint with Brannigan County Code Enforcement, alleging that Voss Cattle Company's cattle pens, the same pens the survey crew had tried to stake a road through, constituted an unpermitted agricultural structure encroaching on a public right-of-way, and demanded the county force Walter Voss to remove them. There was no public right-of-way. Ranchgate Road had never been dedicated to the county. It had always been, and remained, a private ranch road on private land. But the complaint triggered an inspection anyway, cost Walter 11 days and $400 in surveyor fees to definitively prove his own pens sat entirely within his own property lines, and put his name, for the first time, into a county code enforcement file next to the word violation, a word that would not appear on the actual finding, which came back fully in his favor, but that would appear, 3 weeks later, in a post on the Red Hollow Ranch Estates community Facebook group, where a homeowner named Kaylee Torres wrote that the guy who owns the ranch behind us is under county investigation for illegal structures, a claim that was false, unsourced, and shared 41 times before anyone corrected it. Walter Voss found out about the Facebook post from Dale Crenshaw, same as always, over the same fence line. He read it standing in his kitchen, the way he'd read Todd Farrar's nuisance complaint 3 years earlier. And this time, when he called Renata Ibarra-Cole, he didn't ask her what his options were. He told her to file. The lien filed against 60 families' collective peace of mind. The survey crew sent packing by a sheriff's deputy. A false rumor spreading online. Walter just made a critical move. He told his attorney to stop negotiating and start litigating. Right call? What's your strategy here? Voss Cattle Company versus Red Hollow Ranch Estates Homeowners Association was filed in the 274th Judicial District Court of Brannigan County on May the 20th, 2024, docketed as Cause Number 24-0871-CV. The petition asked the court for three things: a declaratory judgment confirming that the 2003 easement had expired in 2013, and that the association's continued use since then constituted, at most, a revocable license, an injunction preventing the association from widening, paving, or otherwise altering Ranch Gate Road without Walter Voss's written consent, and damages for the trespass committed by the survey crew, plus attorney's fees. It did not, notably, ask the court to shut off the association's access entirely, a nuclear option Renata Ibarra Cole still believed would look vindictive to a jury, no matter how legally sound. Instead, the lawsuit's core ask was almost dry, almost bureaucratic, a court order simply confirming what the recorded documents already said, and a permanent injunction stopping the association from touching Voss land without Walter's signature. The association's response, filed 6 weeks later by Grant Pelletier, doubled down on the prescriptive easement theory, added a claim of estoppel, arguing Walter Voss had waited too long and let the association rely on the road to its detriment, and, in a move that Renata Ibarra Cole would later call a gift she never expected to receive in writing, attached as an exhibit a copy of the association's own 2014 board minutes, in which Barbara Suttle explicitly noted receiving Walter Voss's proposed easement renewal and recommended the board approve it. The exhibit, meant to show a history of cooperative dealings, instead proved in the association's own words that its leadership had known, as early as 2014, that the easement required renewal, that Walter Voss had proactively offered one, and that the board had simply chosen not to sign it. Word of the lawsuit reached the neighborhood roughly the way most bad news reaches a subdivision: badly and sideways. Marguerite Doss Kellerman did not send a formal notice to homeowners for 11 days after being served, a delay her own board minutes would later show was spent trying, unsuccessfully, to get Grant Pelletier to draft language that made the lawsuit sound like Walter Voss's overreach, rather than a predictable consequence of 7 years of an unsigned drawer. When the notice finally went out, as an email, then as the agenda item that triggered the July meeting at the Grange Hall, it used the phrase "frivolous claim" twice and did not mention the word easement had ever expired at all. That was the meeting where Todd Farrar's hand shook reading from the page. That was the meeting where the woman by the coffee urn cried because she had bought her house in Red Hollow Ranch Estates 18 months earlier, specifically for the school district, specifically because it was the only route her daughter's bus could reasonably take, and she had never once imagined that the road was a legal question at all, rather than a physical fact, as permanent and unremarkable as the ground itself. Dale Crenshaw stood up at that meeting, in front of 61 furious neighbors, and said the thing nobody wanted to hear, which was that he'd known Walter Voss for 11 years, that Walter had tried to fix this the polite way twice, and that the board had buried both attempts in a drawer without telling a single homeowner they existed. He was booed by roughly a third of the room and applauded, quietly, by another third, and the meeting ended without a quorum for any formal vote at all, because 31 people walked out before the board could even open the floor to comments. Now that you've seen the meeting fall apart in real time, has your HOA ever hidden something this big from you? Tell me the worst thing your board buried in a drawer and never told you about. The discovery phase of Voss Cattle Company versus Red Hollow Ranch Estates Homeowners Association ran from August through November of 2024, and it did more damage to the association's credibility than the lawsuit's core legal question ever could have. Renata Ibarra-Cole requested and received 18 years of board meeting minutes, the association's full financial records back to 2006, every piece of correspondence between the board and Walter Voss, and the paving contractor's complete file on the Phase 3 widening project. What came back painted a picture considerably worse than a board that had merely lost track of a deadline. The minutes confirmed, in Barbara Suttle's own careful cursive, transcribed by whichever volunteer secretary was on duty that year, that the easement's 10-year term had been mentioned at 3 separate board meetings between 2013 and 2016, and that a motion to formally negotiate a renewal had been raised and tabled, without a recorded vote, in 2014, 2015, and again in 2017, under Marguerite Doss Kellerman's presidency, the same year she would later claim, in her sworn deposition, that she had no memory of any easement issue being raised before 2024. The financial records were, if anything, worse for the association's public image than its legal position. The $11,000 road maintenance reserve fund that had accumulated since 2006, the fund homeowners assumed existed specifically to handle situations like this, turned out to have been quietly drawn down 3 times between 2019 and 2023, for a total of $9,200 to cover cost overruns on the association's entrance monument sign, a stone and ironwork structure bearing the taxidermied longhorn skull that Callum Reyes had commissioned back in 2006 and that the board had voted, in 2019, to refresh with new landscape lighting and a repainted crest. The road fund meant to negotiate access to the only highway the subdivision touched had been spent, almost entirely, on decorative lighting for a sign nobody needed to drive past to get anywhere. Priya Nandakumar, the treasurer who had first surfaced Walter Voss's buried renewal proposal in 2019, resigned from the board in September of 2024, 3 weeks after being deposed, and released a public statement to the remaining homeowners, not sanctioned by the board, sent from her personal email to the community listserv, stating plainly that she had raised the easement issue at every annual meeting since 2019 and had been outvoted or ignored each time, and that she could no longer, in good conscience, sit on a board that told homeowners this lawsuit came out of nowhere. It did not come out of nowhere. It came, very precisely, out of a filing cabinet, 3 tabled motions, and $9,200 spent on a stone sign shaped like a cattle skull instead of a road that led, literally, to the only way out. The paving contractor's file, meanwhile, produced Del Aycock's deposition testimony, under oath, that Todd Farrar had told him directly, in a phone call recorded in the contractor's own project notes, that the strip's basically ours, we've been using it for 20 years, don't worry about a survey release from the rancher. That testimony effectively ended any argument the association's attorney could make that the trespass onto Voss land had been an innocent mistake. It had been a decision, made by name, by a sitting vice president of the association, based on an assumption about property rights that Todd Farrar had never bothered to verify with an actual attorney before greenlighting a survey crew onto someone else's cattle pens. $9,200, pulled from the road maintenance fund and spent on a landscaped entrance sign instead of the easement negotiation that could have prevented all of this, against 60 families who had no idea. Is this how your HOA spends its reserve fund? Would you have ever found out if a lawsuit hadn't forced it into the open? By December of 2024, the association's legal position had collapsed to the point that Grant Pelletier quietly withdrew as counsel, citing a fundamental disagreement over litigation strategy in his motion to withdraw. Legal speak, Renata Ibarra-Cole told Walter privately, for a lawyer who had finally read the actual 2003 deed language and realized his prescriptive easement theory had never had a chance. The association hired a second attorney, a litigation specialist out of San Antonio, named Foster Whitlock, who had handled HOA disputes for over a decade, and who, within his first 2 weeks on the case, sent Marguerite Doss Kellerman an email, later produced in discovery, advising her, in blunt terms, that the association's prospects at trial were poor to very poor, and that settlement, on terms that would almost certainly include a substantial permanent easement payment to Walter Voss, was the only path that doesn't end with 60 households facing a real, physical access problem. Marguerite did not want to hear it. She had, by this point, spent nearly 8 months telling the community that Walter Voss's lawsuit was frivolous, an old man's grudge, a cash grab, a phrase she used in an October community newsletter that Renata Ibarra-Cole would later enter into evidence as proof of the association's ongoing public mischaracterization of a legal claim its own attorney privately conceded was strong. She pushed forward toward trial over Foster Whitlock's written objection, in part because, as it came out during a contentious November board meeting that finally hit quorum, she had convinced herself, and told the board, that no judge in Texas is going to let 60 families lose their road over some paperwork. Judges in Texas, it turned out, care quite a lot about paperwork, particularly when the paperwork is a properly recorded, unambiguous, expired easement, and the opposing argument rests on a legal doctrine that requires hostile use the facts explicitly contradict. The homeowners of Red Hollow Ranch Estates, meanwhile, had begun organizing on their own, separate from the board's increasingly defensive messaging. Dale Crenshaw, Priya Nandakumar, and 11 other households formed an informal group they called the Ranch Gate Coalition, and in January of 2025 filed a Texas Public Information Act request, Texas's version of a FOIA request for governmental bodies, though homeowners associations are private entities and technically fall outside its scope, a fact several board members pointed out with some relief, until the coalition's members simply exercised their existing statutory rights under the Texas Property Code instead, which requires homeowners associations to make books and records, including financial statements and board minutes, available to any member of the association upon written request. That request produced the same $9,200 reserve fund drawdown Renata Ibarra-Cole had already found in discovery. But this time, it went out to all 60 households directly, in a plain document with no board spin attached, and it landed at a moment when patience with Marguerite Doss Kellerman's leadership had already worn dangerously thin. In February of 2025, the Ranch Gate Coalition filed a formal petition, signed by 38 of the community's 60 homeowners, comfortably above the majority threshold the association's bylaws required, demanding a special meeting to consider recalling Marguerite Doss Kellerman and Todd Farrar from the board under Article 9, Section 9.2 of the community's CC&Rs, which permitted removal of any officer for cause, including breach of fiduciary duty to the membership. Priya Nandakumar just made a critical move. She went from quietly resigning to publicly organizing 38 of her neighbors around a recall petition, using the same records the board tried to keep buried. Was that the right call? What's your strategy when your board won't listen? The recall meeting was scheduled for March the 11th, 2025, at the same Grange Hall where the whole thing had first erupted 8 months earlier. It did not, in the end, need to happen the way anyone expected, because the trial came first. Voss Cattle Company via Red Hollow Ranch Estates Homeowners Association went before a jury in the 274th Judicial District Court on February the 24th, 2025, presided over by Judge Colette Marchetti, and it lasted 4 days, considerably shorter than either side's attorneys had originally estimated, largely because the association's own evidence kept doing the plaintiff's work for him. Renata Ibarra-Cole's case was, by design, unglamorous. She walked the jury through the recorded deed, the 10-year term, the August 2013 expiration date, Walter Voss's two documented attempts to negotiate a renewal in 2014 and again in 2024, and the association's own board minutes acknowledging all of it, while doing nothing. Foster Whitlock, representing the association at trial in place of the attorney who had walked away from the case, did what he could with a losing hand. He argued equity, that 60 families shouldn't lose their only paved access over a technical lapse, that Walter Voss had waited too long to act, that basic fairness demanded the court find some way to preserve the community's access regardless of the deed's precise language. It was, Judge Marchetti noted in her instructions to the jury, a fair argument about consequences and a poor argument about the law, because Texas courts do not have the authority to rewrite an unambiguous recorded easement based on sympathy for the people relying on it, however sympathetic those people might be. Walter Voss took the stand for just under 2 hours and testified in the same even engineer's cadence he'd used to describe drainage systems to state committees for 2 decades, that he had tried, twice, in writing, to give the association exactly what it needed, a permanent, fairly compensated easement, and that both times the board had simply declined to respond. He testified that he had never once, in 11 years since the original easement expired, denied a single homeowner passage, called the sheriff on a school bus, or done anything at all to interfere with the community's daily use of Ranch Gate Road, right up until a survey crew showed up unannounced to stake a road through his cattle pens. "I'm not the one who created this problem," he told the jury, when Foster Whitlock asked him directly, on cross-examination, whether he understood what a ruling in his favor could mean for 60 families' access to their homes. "I offered to solve it twice. Somebody put my offer in a drawer twice. I didn't put it there." The jury deliberated for just under 6 hours. On February the 28th, 2025, they returned a verdict finding that the 2003 easement had expired by its own terms on August the 14th, 2013, that the association's continued use of Ranch Gate Road since that date constituted, at most, a revocable license rather than any form of legal easement, prescriptive or otherwise, that the association's survey crew had committed trespass on April the 3rd, 2024, entitling Voss Cattle Company to $4,100 in actual damages, and that Voss Cattle Company was entitled to recover its reasonable attorney's fees under the Texas Uniform Declaratory Judgments Act, a figure Judge Marchetti would later set. After a separate fee hearing, at $86,400, a sum the association's own insurance carrier initially refused to cover, on the grounds that the underlying dispute stemmed from board decisions rather than a covered liability, triggering a second, smaller legal fight between the association and its own insurer that would drag on for another 4 months. The court did not order Walter Voss to grant any new easement. It did not need to. It simply confirmed that none currently existed, and that the choice of whether to grant one, and on what terms, belonged, as it always had, to him. After the verdict came down, expired easement confirmed, trespass damages awarded, $86,000 in legal fees the association now owed. Was it worth it for Walter Voss? Have you ever had to go to court just to get your HOA to acknowledge a fact that was already written down? Tell me your story. The verdict landed in Red Hollow Ranch Estates like a physical shock, because for the first time, 60 households understood, in concrete terms, what no easement actually meant. It did not mean Walter Voss was going to put up a gate the next morning. It meant that he legally could, and that nothing in Texas law obligated him to give 60 families a single day's notice before doing it. The recall meeting on March the 11th happened anyway, and it did not go the way Marguerite Doss Kellerman had spent 8 months insisting it would. With the trial's outcome now a matter of public record, Foster Whitlock had, in fact, briefed the community directly on the verdict at an emergency session 2 weeks earlier, over Marguerite's objection, because he considered it a fiduciary obligation to inform homeowners of a ruling that materially affected every one of their properties. The vote to recall Marguerite Doss Kellerman as president passed with the support of 44 of the 60 households. Todd Farrar's recall passed by an even wider margin, 49 votes, driven largely by Del Aycock's deposition testimony about the phone call in which Farrar had waved off the need for a survey release. Priya Nandakumar was elected the association's new president that same night, unopposed, with Dale Crenshaw taking the newly vacated vice presidency. Their first act as the new board, before even addressing the reserve fund or the road repaving project, was to authorize Priya to reach out directly to Walter Voss and Renata Ibarra-Cole to open, for the first time in 11 years, an actual good-faith negotiation over permanent access. That negotiation took 3 months, ran through April, May, and most of June of 2025, and produced a result considerably different from either the informal $100 per household arrangement Walter had proposed back in 2014, or the aggressive, prescriptive easement fantasy the old board had tried to litigate. Walter Voss agreed to grant Red Hollow Ranch Estates Homeowners Association a new, permanent, recorded easement across the original Ranch Gate Road alignment. The same footprint his father had graded in 1974, no widening, no encroachment onto the cattle pens, in exchange for an upfront payment of $48,000, representing fair compensation for the easement itself, plus reimbursement of a portion of his litigation costs, and an ongoing annual maintenance fee of $9,000 a year, adjusted for inflation every 5 years, funded through a dedicated line item in the association's budget that the new board committed, in writing, in the amended CC&Rs, could never again be redirected toward unrelated capital projects without a full membership vote requiring at least 2/3 approval. The new easement, recorded in July of 2025 as instrument number 2025-098213 in the Brannigan County Real Property Records, ran for a term of 50 years, with automatic 10-year renewal windows built directly into the instrument's language this time, each one triggering an automatic notice to both parties 18 months before expiration, a clause Renata Ibarra-Cole insisted on personally, so that no future board, however careless or however convinced of its own permanence. The $48,000 upfront payment came out of a special one-time assessment the new board proposed and put to a membership vote in May of 2025. $800 per household, a fraction of the $2,400 assessment the old board had tried to force through for an illegal widening project the year before. It passed with 91% approval, because for the first time in the association's history, every homeowner understood exactly what they were paying for and exactly why it mattered. The old board fought a lawsuit for 8 months to avoid paying Walter Voss what he'd offered to accept back in 2014. Would negotiating early have saved everyone this pain? Or was the fight always coming? By the fall of 2025, Red Hollow Ranch Estates looked, on the surface, almost exactly the way it always had. School buses still turned down Ranch Gate Road every weekday morning. Dale Crenshaw still waved at Walter Voss's truck when they passed each other at the cattle guard, same as he had for 11 years, except now the wave came with an easement instrument, number both men could recite from memory if they had to. Voss Cattle Company still ran 140 head of Santa Gertrudis on 412 acres, and Walter Voss still woke up before dawn to check water troughs and mend fence line, the same routine his father had kept for 50 years before him. What had changed sat mostly in paper, but it was paper that mattered. The association's amended CC&Rs, ratified in August of 2025, added an entirely new article, Article 14, Easements and Access Agreements, requiring the board to conduct a full title and easement audit of every recorded access right benefiting the community at least once every 5 years, and to disclose the results in writing to every homeowner, whether or not any problem was found. Priya Nandakumar, in her first president's letter under the new rule, wrote that the audit existed so that no family here ever again finds out their road has an expiration date from a neighbor's lawsuit instead of from us. The reserve fund, rebuilt over 18 months of disciplined budgeting under the new board, sat at $22,000 by the end of 2025, more than double what it had been at its peak under the old leadership, and this time earmarked, by an explicit line in the budget minutes, exclusively for road maintenance and easement obligations, with the entrance monument's decorative lighting quietly moved to a separate, smaller discretionary account that required its own annual vote to fund. Marguerite Doss Kellerman moved out of Red Hollow Ranch Estates in October of 2025, selling her house on her own terms rather than waiting to see whether the community's opinion of her would soften with time. She sold at close to market value. Brannigan County's housing market had held steady through the entire dispute, the eventual settlement having done more to protect property values than the lawsuit ever threatened to damage, and left, according to Dale Crenshaw, without much fanfare and without much of a goodbye either. Todd Farrar stayed, kept a lower profile at community events, and did not run for the board again. Walter Voss, for his part, never sought any of it out. He hadn't wanted to be the reason a Grange Hall full of families spent an evening screaming at each other over a folding chair and a vice president's shaking hands. He had wanted, from the very first letter in 2014, a signed piece of paper and a fair number, and it had taken 11 years, one collapsed prescriptive easement theory, a wrongly targeted code enforcement complaint, a Facebook rumor, and $86,400 in legal fees paid by 60 households who had never asked to be part of any of it, before he finally got exactly that. He keeps the original 2003 deed in the same filing cabinet where his father used to keep cattle inspection records, alongside a copy of the 2025 renewal, instrument numbers stamped side by side, 22 years apart. When Dale Crenshaw asked him once, over that same fence line, whether he ever thought about just letting the whole thing go back in 2024, taking the $2,400 assessment fight as somebody else's problem and staying out of it, Walter Voss reportedly said only that a man who spent 30 years designing roads for the state of Texas has a hard time watching one get built on paper that doesn't say what people think it says. The road is still there. It still leads to the highway. It's just recorded correctly now, and there's a clock built into it that nobody, this time, is allowed to forget is running. If your HOA has ever tried to tell you a right you assumed was permanent actually expired years ago and nobody bothered to mention it, or if you've ever discovered your own board spent the money meant to protect you on something else entirely, drop it in the comments below. Subscribe for more stories from behind the gate, because in America's homeowners associations, the paperwork always outlasts the people who ignored it.